Okay, let's unpack this. Today we're diving into Haltom v. City of Henderson TN Police Department.
Yeah, this is a civil rights lawsuit, but definitely not ordinary.
Not at all. It's this really fascinating look at how deeply personal beliefs sort of collide with the legal system's framework.
And we're pulling this straight from the court filings, the judicial reports themselves.
Right. So our mission here is to find the most surprising nuggets, the really insightful bits in this unique case. Okay, so at its core, like you said, civil rights claim, it's brought under 42 U.S.C. Section 1983.
The key federal law for suing government officials over constitutional violations.
Exactly. And here, the plaintiff, Joshua Haltom, he's alleging systemic stuff: religious discrimination, retaliatory citations, unlawful arrests.
Right. The religious discrimination part, for instance, seems to stem from his refusal to follow certain police orders based on his spiritual convictions.
But here's where it gets, really interesting. He's representing himself, per se.
And his approach is just different.
Very.
Yeah, what's really compelling is how he mixes these, conventional legal claims, the discrimination, the arrests, with these deep philosophical, even spiritual arguments.
Like?
Well, he identifies as sui juris.
Okay, what does that mean in this context?
It essentially means claiming to be outside the usual legal jurisdiction, sort of self-governing.
Yeah.
And he cites divine law, talks about spiritual trespass. He even challenges what he calls the all-CPS construct of his identity.
The all-CPS, on legal documents.
Exactly. These are arguments you sometimes see linked to sovereign citizen theories, people claiming exemption from laws.
And how do courts usually handle that?
Federal courts typically find these arguments legally non-cognizable. Meaning they just don't have a basis in this established U.S. law. They don't fit the framework the court operates under.
So if his core beliefs, these really deeply held ideas, don't fit that legal box, how does the judge even proceed? How do they stop the whole thing from just, dismissing his view out of hand?
That's the real tension, isn't it?
Yeah.
The judge has to ensure due process. That's fundamental. Even for a pro se litigant with unconventional arguments.
But they still have to apply the law.
Strictly. It means meticulously separating the claims that do have a potential legal basis under federal law from the arguments, however sincere, that just don't.
And it gets even more complex, right? Because he's looking beyond just the courtroom.
He is. He talks about seeking irreversible public accountability.
And he actually says the jury is now the internet.
Right. Believing that because these court documents are public, archived online, the alleged violations cannot be erased.
That's quite a statement. It's like seeing public opinion, the digital record, as a parallel court system almost.
It definitely challenges the traditional idea of justice happening within the courtroom walls.
So, connecting that dot, what does this mean for Judge Thomas Anderson, who's handling this?
Well, it adds another layer to an already critical task. That demand for public accountability via the internet, it changes the whole dynamic.
It's not just about a legal judgment anymore.
Potentially not for the plaintiff, no.
And if you thought his core arguments were intriguing, his moves on court procedure are also pretty fascinating.
Yeah.
He's pushing for summary judgment, basically asking for a quick win without a full trial.
On what grounds?
Alleged judicial default. Claims the other side didn't respond properly, and he's also asking for sanctions against the defense lawyers.
Okay, sanctions under Rule 11 for bad faith tactics.
Exactly. Federal Rule of Civil Procedure 11. Penalties for frivolous filings.
So he's using the court's own rules aggressively.
He is. But then here's the twist, the kind of contradiction. He waived his right to a jury trial, said it was for an expedited resolution.
Okay, waive the jury.
But at the same time, he requested a public hearing. Why? For transparency, public scrutiny, and broader awareness.
So waive the jury for speed, but demand a public hearing for awareness. That does raise a question.
What's the ultimate goal here?
Exactly. What's the priority? The judge probably sees that jury waiver as an opening, streamline the case, maybe encourage a settlement.
But the public hearing demand.
That suggests he wants public vindication, which kind of complicates a quiet, confidential settlement, doesn't it?
It really does. So the judge has to filter all this.
Carefully filter the arguments, provide really clear guidance on what the legal requirements actually are, regardless of the plaintiff's personal beliefs, basically map out the legal road.
But isn't there a risk there? That in trying to streamline and guide according to the law, the court might, maybe unintentionally, silence the very unique perspective Haltom is trying to bring, even if it is unconventional.
That's the tightrope walk. Always is in cases like this.
Yeah.
The judge has to uphold legal tradition, precedent, the established rules, while still giving this unique litigant a fair shake under due process. The court's job isn't to validate or dismiss the personal belief itself.
It's to apply the law.
As it stands, yes.
Wow. Okay. So this deep dive into Haltom v. City of Henderson, it really just lays bare that tension, doesn't it? Between individual belief, the court's impartial structure, and this whole idea of justice in our very digital age.
It really does. And it makes you wonder, when someone declares the jury is now the internet, how does that start to reshape how we even think about accountability versus a formal legal judgment?
Right.
And how does a court navigate that? This desire for both a specific legal outcome and this broader, maybe more cultural public vindication. It builds on that interesting idea he mentioned, that culture changes when the organization is transformed.
Lots to think about there. Definitely something to mull over.